Started. All right. So we're going to talk about arbitration and as is. I get a lot of questions about this, so I thought it'd be great to just do a quick little training session on it. We're not going to dive deep into these topics, but just going to give you enough to make you feel a little bit more informed on these two subjects, and also open it up for any questions that you guys may have. All right. So what is arbitration? Arbitration is a dispute resolution process that's used in an alternative to the court system. Rather than suing the opposing party in a court of law, a complainant would file a demand for arbitration with National Center for Dispute Settlement, and an arbitrator would be assigned to the case. The arbitrator would then oversee the procedural and substantive issues that arise and issue a decision that is binding upon all parties. So here's what you need to know about arbitration. By agreeing to arbitration, you give your right to go to court for anything over $15,000. The reason for this is anything under $15,000 goes through small claims court, because small claims court max amount is $15,000. So that's why arbitration starts at $15,000. The agreement to go through arbitration is only valid if it's signed by all parties. So that means all buyers, all sellers, and all licensees. So if one licensee or one of the four parties doesn't sign, it's not valid. Now, if a party declines arbitration or does not agree to arbitration at the time of the purchase agreement, you could all still agree to go to arbitration later, if all parties at that time agreed. However, if you all agree to arbitration and sign it, and later someone says they don't want to do arbitration, that's not an option. So again, it's a private dispute resolution system that's in an alternative to the court system. The admin fee for the arbitration system varies depending on the amount of the claim. I have a screen on this later, depending on the price range, depends on the actual fee that the initiating party would pay to start the arbitration process. It can be more than initial court filing fees, and in some cases, Constellation Court is cheaper than arbitration. A request for arbitration must be filed within 24 months of the date of the closing on the property, or the claim cannot be pursued. 1 minute, I have other people asking to come in and I can't multitask. Arbitration is simply for dispute disclosure of material facts that affect the use or enjoyment of the property. This includes claim of fraud, misrepresentation, warranty, and negligence. So a good example I have of that, I always like to share examples. That's how I learn. I sold actually my very best childhood friend a home a few years ago. We closed in October. The next spring, it was a few years ago when we had a really heavy, wet spring. Almost everybody's basements were flooding. Her basement flooded. As they're ripping everything out of the basement and pulling it into the driveway to dry it out, neighbors start coming over. Oh, the sellers had this issue for quite a few years, that their basement flooded every spring. So my friend calls me, I'm flipping through all the disclosures. Nothing was ever disclosed by the seller. That would have been a perfect, back then, arbitration was actually for things at a lesser amount. So it wouldn't apply now, but it only ended up being a couple $1,000s for them to fix the basement, and she thought it wasn't worth their time and energy to go through arbitration. But literally that would have been a prime example of where arbitration came into play, because the party who's bringing the claim to the courts, the proof of burden lies on them. And it's usually going to be the buyer, right? It's hard for me to really determine in a circumstance the seller would bring a dispute, but it's typically a buyer feeling like something wasn't disclosed to them and has affected them later on. And it's really, the proof is on the buyer. Something. I've seen instances situation. Sorry, I'm trying to figure out who's not muted on here. I've seen situations where post-close a furnace went out and a buyer called a random HVAC company who came out and was like, oh, we were actually out here 6 months ago. We have the invoice and we told the seller XYZ needed to be done. The seller failed to disclose it and didn't do the work. But it's really hard otherwise to prove that the seller knew these material facts. So party else is not muted here. Okay. The party bringing the claim files demand and the necessary fees with that NSDS. NSDS works with parties to assign and appoint an arbitrator. Typically, only one arbitrator is appointed to these cases. A 3-point panel can be appointed instead of a 1-party panel, but the requesting party who wants the 3 different arbitrators pays additional fees to have the additional arbitrators on. Arbitrators have backgrounds in law, real estate, architecture, engineering, construction, and other related fields. This is also where arbitration can benefit you versus going to the court system, because a judge doesn't know all of these things, right? By going in front of a panel of arbitrators or one arbitrator who might have a specialty knowledge in the specific item that you're going to arbitration for could be beneficial versus a judge who doesn't really know. Hearings are typically held on site at the property. So all parties would go to the property to complete the arbitration and kind of argue their side of the story. Just because you sign arbitration doesn't mean that you can't be represented by a lawyer at the hearing. So even though you're agreeing to arbitration, you can still agree to have an attorney on site and represent you through the arbitration case. Obviously, that would be more money. The arbitrator must make a decision within 30 days of the final hearing date. The arbitrator does not have to make findings of fact and explain the reason for granting or denying an award. So going to court, where I was explaining a judge might not have all of these, the background like an arbitrator does, right? But the judge has to make a ruling based on the facts that were presented to them and explain kind of why their ruling came out, where an arbitrator doesn't. They just can make a decision. The arbitrator can also, in their rulings, have the party that didn't win pay all different fees. So to arbitrate or not, arbitration can be typically quicker than litigation. This can happen in just a few months, where hiring an attorney and going through the court system can drag on for months, if not years. Arbitration has more simplified rules of evidence and findings. Again, that goes back to the knowledge of the arbitrator versus the judge. The judge is going to want all that information to make what they feel like is, you're providing them all the information they need to make a solid decision, where an arbitrator might just have more background knowledge than that judge. Because it's not a court case, it's private. So all court cases are typically public knowledge, and you can look up who's been involved in a lawsuit. With arbitration, that doesn't happen. And in arbitration, both parties get a say in who the arbitrator is, and one that can be an expert on the subject matter. So not going too deep into it, but part of the arbitration process is that National Center for Dispute, after the claim is made, they send out to all parties a list of arbitrators. I think a little synopsis of like what their background is. So then all parties can also ixnay some arbitrators, or, you know, agree on all parties want the same arbitrator. Our people also have to like back down when they hear of the case if they have any like connections with either party. The reason not to arbitrate, the right to appeal an arbitrator's decision is very limited. You know, anything's possible, but reality is pretty much the final decision the arbitrator makes is final. And if one party doesn't like it, you can't then bring it to court or try and bring it back to arbitration. The cost to start, again, an arbitration case can often exceed the court filing costs. And the process is not subject to the same rules of evidence and discovery as a court case. So this can raise questions of fairness and transparency. So the interesting thing about choosing whether to do arbitration or not is some of the benefits of arbitration are also some of the downfalls of arbitration, and vice versa. So the cost for filing arbitration, if you guys want, I can post the links to where you actually file an arbitration case and this fee schedule, because these are also always changing. But so between $15,000 and $25,000 is a $1,500 filing fee. And then between 25 and 50 is 2,000, so on and so forth. And then the next section shows what the cost of this is if you want that 3-party panel for arbitrators versus just the one. And then if you guys want more information, if you want to read through the things in MLS itself, we have this a form called arbitration information. So you might have noticed when you go to search the ARB form, like 3 different things came up. One is like an 11-page arbitration information sheet that explains to you pretty much everything that I just went through. But here's the link if a client ever wants to actually go file an arbitration case. This is where they would start. They have to file the claim, fill out all the necessary paperwork, pay the fee, and then the claim is opened. All right, getting back to, want to say that that's the last slide I have on arbitration. Do you guys have any questions on that?
So they have to agree on the same arbitrator?
I've personally never been through an arbitration process. I don't know that everyone necessarily has to agree on it, but you have the right to like strike out. Okay. You know what I mean? Like, again, like if you as the seller were getting an arbitration case against you and you were in a court situation where this arbitrator was a witness and that they could be unrelated, but you're like, well, I feel like that's a conflict of interest. You can explain them out, kind of like a judging. What I've never been to court either, but when you go through like a case, you know, both prosecutor and defense can decide they can pick people out because you wear glasses and they don't want someone who's wearing glasses in the judge, you know? So yeah. Any other questions on arbitration? You guys feel like that helped just at least shed a little bit more light for if your clients are ever going through a situation like that, you're not just like, I have no idea. Yeah.
Hey, Kassie.
Oh, hold on one second. Whoever's on Zoom, I have an in-house question, then I'll go to you. Go ahead.
Okay, sounds good.
Dustin question, do both parties have to pay it? Typically, it's just the party that's bringing the suit that pays that initial filing fee, but that's where also the arbitrator at the end, if the party who brought the case is in fact the prevailing party, the arbitrator will likely make the other party pay the filing fee as well. The other thing that really stinks is even if you prevail in arbitration, there's no guarantee for payment. Same with if you go to court though, right? They're just making a call on it and one party or the other wins. And even if you win, it doesn't guarantee payment. It's not like the arbitrator is collecting payment from the losing party and giving it to the winning party. You still got to collect it from them. And if they refuse to pay, then you got to take them to court and put a judgment against them. All right, who is on Zoom that had a question?
Hey, Kassie, it's Sharon.
Sharon.
So here's a statement and then a question. I have actually been involved in arbitration where I was the buyer and went against the seller who was the agent, owner, and builder of the property. And I would say if I knew then what I know now, it would have been a completely different outcome. That being said, though, touch on, and I think I know the answer to this because I actually have a client that had to go through arbitration also, but just touch on for all of us our responsibility once it goes to arbitration.
Well, it really depends on what the case is. I mean, typically you're supposed to be there, right? Especially if because you can call witnesses and stuff in arbitration as well. And the arbitrator can decide who they want to ixnay for witnesses as well. But Sharon, as far as the responsibility goes, ultimately, I would think we would need to bring this to the EXP broker level and see what their expectation of us is as agents.
Okay, thanks.
Yep. All right, any other questions on arbitration? All right, I'm gonna go into as is. And this comes up quite a bit because I feel like the term as is used very loosely by agents in our industry. A lot of times you'll hear agents or you'll call agents and they'll say, well, this is an as is sale. An official as is sale isn't an as is sale unless an as is addendum accompanies it, okay? So when an agent says as is, what they're typically just meaning is the seller doesn't intend on doing any repairs. That's what they mean by as is. So I want to be clear on that. Seller typically won't plan on making any repairs, but it doesn't mean you can't do an inspection and still negotiate a price reduction or closing costs if you haven't exceeded those amounts. But where it becomes different is when an actual as-is addendum is in play. So if the listing agent has an as-is addendum in supplements already signed by seller, which sometimes they do, or they specifically indicated in like agent remarks or on a conversation with them that this is an as-is sale, what that's doing is an as-is addendum pretty much makes the seller not liable for anything regarding the sale. It's not in your buyer's best interest, right? There's really no recourse to the seller when an as-is addendum is signed at the time of a purchase agreement. Just limits the seller's liability. So what you need to know is a seller should not be completing a full disclosure statement if choosing an as-is addendum. They should be doing the seller's disclosure alternative. If you run across a property that they have the as-is addendum and a full disclosure, the as-is addendum itself states that they should contact an attorney. A disclosure alternative is what should be completed by the seller with the waiver section completed. And even though the seller may be waiving any of their disclosure, they still remain obligated to disclose what they do know in the other section. So in the disclosure alternative, the other section includes, do you know of a well? Do you know of septic? Do you know of lead, maybe not lead-based, but radon and a couple other things. The seller doesn't have the option or opportunity to mark NA on those things. That section should still be completed. So when you're doing an as-is sale, and again, the as-is sale is in the formal sense of an as-is addendum has been signed. The buyer's basically accepting the property and the condition of the property subject to the purchase agreement. So let's say in the initial purchase agreement, you do have an as-is addendum, but in there it said something like, you know, seller to paint the hallway. They're still supposed to complete that because that's what was agreed to in the purchase agreement, but the seller doesn't have any other obligations for anything post-closing. Dustin, do you have a question?
So they're not obligated if something came up. But they needed something to make the deal happen. Would you still negotiate it, or is
Yep. So in an as-is, whether it's an official or unofficial, and have I been clear on
Sorry,
that?
Cassie, can you just repeat his question? I couldn't hear it here on Zoom.
Yeah, his question is basically just, can we still negotiate repairs, right? And yes, in either form, whether we're having an unofficial as-is sale or an official as-is sale, you can still try and negotiate. But that's where I was trying to drive point the home earlier. Like a lot of agents say, well, this is an as-is sale, but they really don't have the as-is addendum. They're just saying that because the seller doesn't want to make any repairs. Maybe they acquired the home through a death in the family, whatever the case is. They might just be saying, I don't want to use my time, money, and resources to make the repairs, but if you as the buyer do a home inspection and you find $20,000 in repairs, they might still be willing to drop the price or pay additional closing costs. It just means they don't typically want to do any repairs themselves. But agents just so often get this confused. Like an as-is sale really isn't an as-is sale without the addendum. They just loosely use that term when the seller just in fact doesn't want to make any repairs. So buyer waives any claims related in any way to the condition of the property. So going back to, unless the agent, so even if I were to call an agent and they said this was an as-is sale, but they didn't have in agent remarks the as-is addendum, they didn't have it in supplements, or they didn't tell me to include one, I'm not going to include one. I'm going to assume they just meant seller doesn't want to make any repairs. Why am I not going to include one? Because an as-is sale is really not in the buyer's best interest. It limits their ability to make any claims post-closing. So I would submit my offer without it, and I'd allow them to come back to me and say, I need the as-is addendum. But again, if it's specifically stated in MLS agent remarks, I'll send it. But unless I'm specifically requested for this addendum, no matter what the agent has said to me, I'm not going to submit it with my offer. So here's just a copy of that as-is addendum that goes over pretty much everything that I just said. It's being sold in its existing condition. Buyer acknowledges that the property, including all improvements, is being sold in as-is, where-is basis. And seller and buyer shall execute a disclosure statement, seller's disclosure alternative with the waiver section completed. Seller remains obligated to make other required disclosures in the other section. I already talked about that. The other section of the disclosure alternative talks about well, septic, etc. And then this addendum will affect the legal rights of buyer and buyer and seller are strongly encouraged to obtain legal advice before agreeing to this addendum. So if this addendum is used, make sure you're at least advising your buyer to seek legal advice. I've never had anybody do it, but doesn't mean they shouldn't. It doesn't mean someone won't. And this is thinking. I think that was the last page of this anyways. So, guys got any questions?
Does this stop you from being able to go to arbitration later, like you're fully accepting it?
So the question in-house was, does as-is stop you from going to arbitration later? I mean, if you all signed arbitration, no, but I think you'd go to arbitration and completely lose because the arbitrator would say, well, you signed this as-is addendum, which means you're accepting the property in its wholehearted condition.
Yeah.
Right? So I would say it's probably a waste of someone's time. If I had a client come back to me and said that they wanted to file an arbitration case and I saw that we had all signed arbitration and we had all signed an as-is addendum, I would advise them, you know, like file your claim, but you're probably not going to go anywhere, or maybe seek a real estate attorney who can better advise you if this makes sense to go through arbitration. I would also say if you're representing a seller and an as-is addendum is signed, I'd probably have them waive arbitration. So, all right. As always, I hope you guys found this helpful. I feel like I must talk really fast because we have these scheduled for like an hour and in 20 minutes. I'm like, great. Does everybody get this clear as day?
Thank you so much, Cassie.
You guys are welcome. I hope at least it provided a little bit of extra knowledge and makes you feel a little bit more confident when explaining it to clients. Make sure when you're doing the arbitration addendum, especially if you're signing in Instinet, that you're doing the drop down for optional signature and not just forcing them to sign. You don't want to be caught up in a situation where they feel like you forced them to sign arbitration when they in fact didn't want to be. Especially if they're now going towards a suit of any kind, whether they're leaning towards arbitration or court, they're going to look at you as their agent to find any way to make you at fault for something. All right, guys, that's all for today. Thank you for joining me, and we'll see you at noon for the team meeting.
Thanks, Cassie.
Welcome.